Hi guys, welcome to Commercial Law Tutorials. Under the topic Law of Contract, we have already covered the definition, formation and essentials of a valid contract, offer and acceptance, advertisements, valid, void and voidable contract, important terms used in the law of contract, and breach of contract. Today we are moving on to termination of contract. First of all, we are going to discuss what terminating a contract is. Then we will list and explain ways of terminating a contract. And at the end of the lesson, I'm going to give you popular exam questions relating to this lesson. Let us first define what terminating a contract is. Contract termination is the bringing of a contract to an end after or before the performance has been completed. Note that contract termination is acceptable in law if it is done correctly, but termination of a contract is different from breach of contract. So, how do we terminate a contract? First of all, by performance, mutual agreement, supervening impossibility, extinctive prescription, death, and also insolvency. These are the ways in which a contract can be terminated. First of all, we are going to look at performance. Generally, a contract is terminated when both parties have fully performed their obligations under the contract. That is, both the debtor and the creditor have fully performed what they were supposed to perform in that contract. Then a contract is terminated. If it is payment of money that is required, the debtor should have done the following. The debtor should have made the payment himself or someone on his or her behalf. The payment should have been made to the creditor or an agent having the authority to receive the payment. The payment should be unconditional also. It should be in full and in the manner that has been expressly or impliedly said in the contract. For instance, time of payment, place, or even the way of paying the debt, like which notes or coins, something like that. Then, in a cash sale, the creditor can refuse installments and insist on being paid in cash, which is a legal tender. In a cash sale, the creditor can also refuse to be paid using a check, because a check is not a legal tender. In case a creditor accepts a check, the payment is only conditional. It is a conditional payment, and the debtor is not freed until the check is made on presentation at the bank. That is when the debtor is said to have covered the debt. Next, we have mutual agreement as a way of terminating a contract. Mutual agreements, these are situations where parties in a contract consent to a separation. That is, they agree to end a contract. There are different forms of mutual agreement. That is, different ways of terminating a contract using mutual agreement. The first one is release. This is a bilateral act that is two-way. Both parties are involved. The parties agree that their contract shall come to an end without the debtor having made performance or fully performed. By agreeing to mutual release, each party agrees to give up any claims against the other in any way for breach of contract. The contract would have ended if they agree using release. For instance, the common example we have is divorce, by which mutual agreement is realized where the parties agree that they are no longer compatible and they want to separate. In partnership, this is also realized, where the parties can sell everything and go their separate ways. The second form of mutual agreement is waiver. Unlike release, waiver is a unilateral act, that is, it's one way. It consists of abandonment of a right by the creditor. For instance, a loan waiver, that is, the lender agrees to assume the burden of the loan upon themselves, either partially or fully. They tell the debtor that they should not pay a certain amount of the loan. They have reduced the amount to be paid back to them as a creditor. That is what we call waiver. Then the next one is cancellation. That is the third way of doing mutual agreement. Cancellation of a contract is done usually before the contract has been fully performed. It may be terminated by the parties when they mutually agree to cancel that contract. Where parties had not yet fully performed, the contract is simply dissolved without any further consequences. But where one or both parties have performed partly, what was given in the contract is retained to bring back the parties in the position they were before the contract. Or, if that can't be done, compensation is paid. For instance, after breach of contract or anticipatory breach, the parties can mutually agree to cancel a contract. Still under mutual agreement, let us look at compromise as the fourth way in which parties can agree to terminate their contract. A compromise is an agreement to settle a matter in dispute. Each party then lessens some of his previous demands in the contract, hence creating a new contract with new obligations and new rights, thereby automatically cancelling the previous contract which they had. And finally, we have novation, which is also under mutual agreement. Novation is the substitution of an old obligation with a new obligation. The old obligations are extinguished as if by payment. Then third parties may also be brought into the new contract either by delegation or assignment. So novation is divided into two, that is novation proper and delegation or assignment. First of all, let us look at novation proper. Novation proper is when parties to a contract enter into a new contract which substitutes their existing contract. The old contract is thereby terminated by the new contract entered. For instance, changing design or fee of a dress being sewn by a tailor. Thus, the old design and the old fee are cancelled, and a new contract on a new design, that is a new dress, and a new fee is made. And the parties now deal with the new design and the new fee. That is novation proper. Then when it's delegation season and assignment, it involves the formally giving up of rights and obligations which are then transferred to a third party. A third party is involved in delegation, cession, and assignment, unlike in novation proper. So, delegation, it substitutes a third party in the capacity of a debtor, that is transfer of obligations only. And if it's cession, it substitutes a third party for one of the parties in the capacity of a creditor, that is transfer of rights only. If it's assignment, it substitutes a third party in the capacity of both the debtor and the creditor, that is transfer of both rights and obligations. That was all on mutual agreement. Let us look at supervening impossibility. Supervening impossibility is when performance of a contract obligation becomes impossible, thereby terminating a contract. A contract is made impossible either through vis major, that is, act of God or state. For instance, earthquakes, hurricanes, lightnings, and floods. You can also look at this case. It is a good example of vis major. And we have CASUS FORTUITUS, that is inevitable accident. These are events which cannot be avoided even if ordinary precautions are taken. For instance, unexpected power cuts, which hinder somehow production and delivery of a contract. It is not terminated by supervening impossibility of performance in the following circumstances though: where performance has become impossible as a direct result of debtor's own wrongful act, or when the debtor has taken upon himself the risk of performance being impossible, or when performance is more difficult or costly but not impossible, or where the impossibility is partial. The obligation remains in existence in the part that is still possible of performance, and where the debtor is only temporarily disabled but can surely perform in future. The contract is not terminated by supervening impossibility. The contract remains in existence and binding, and both parties are expected to perform their obligations under that contract in these situations we have just mentioned. Let us move on to extinctive prescription. Extinctive prescription is the loss of a party's right by lapse of time. It is a way of extinguishing the right to pursue an action due to no action due to a certain amount of time which has passed. For instance, in Zimbabwe, we are saying that any debt is extinguished after the lapse of the relevant period which is stated under law. 30 years for mortgage bond, 15 years for a loan of money or sale or lease of land, 6 years for debt of a negotiable instrument, notarial contract, or any debt owed to the state. Then 3 years for any other debt, unless another period is provided by any enactment which affects all these periods stated above. But there can also be delay on the fulfillment of the time or prescription we were talking about previously, and I've given an example of Zimbabwean period times that are considered. There can be a delay when a creditor is a minor or insane or a person under or deserves to be under curatorship. A creditor and the debtor are married to each other or are partners, and the debt which arose out of the partnership relationship is somehow affected. It affects their prescription. Then, if debtor is outside Zimbabwe, creditor or debtor is deceased and an executor has not yet been appointed, that also affects the prescription time. But also note that if the debtor acknowledges the debt at any time, expressly or impliedly, the running of prescription is also interrupted. Or if the due date of a debt is adjusted by the parties in some way, such that they drag it to a future date, the prescription time period is also affected. Prescription period begins again on the day on which the interruption takes place or after the new due date, respectively. Let us look at death also as a way of terminating a contract. Death is the end of life of a person. If one or more parties in the contract dies, what then happens to their contract? That is what we want to discuss. As a general rule, death of a party to a contract does not terminate the contract. The deceased's rights and duties just pass to the executor. That is, if the rights and duties were not personal in some sense, like personal skills. But contracts involving special personal qualities, as we were saying just before, of the deceased are discharged by supervening impossibility of performance. For instance, contract involving strategic planning and management or driving employment contracts, those are automatically cancelled. Finally, let us look at insolvency as a way of terminating a contract. Insolvency is the financial state where a party's liabilities exceeds assets and thereby that person will be unable to pay his or her debts. Insolvency of a party in a contract usually terminates a contract as the party will no longer be able to continue delivering according to the terms set out in the contract due to lack of contractual capacity and the ability to have the funds to do so. For instance, some contracts, like supply contracts, often include a contractual right for a supplier to terminate the contract if the customer enters into some form of insolvency. That is to protect themselves from this situation, as insolvency naturally terminates the contract. That was all I had for you. Let us now look at the common exam questions under the topic. We have examined any 4 ways in which a contract may be terminated. Cite relevant cases. Thank you so much for watching. Remember to subscribe and like.